Hi, I'm Shan Wu with an undercolor of law question for you. What does a 1935 Supreme Court case, Humphrey's executor, have to do with the fall of our government potentially and Supreme Court hubris? Turns out, maybe everything. You remember that word hubris from Greek tragedies, right? And the idea here is that the old ancient Greece tragedies always had somebody who was getting a little bit too big for their britches. Usually there's a fatal shortcoming that brings about the fall of the tragic hero. Remember Icarus flying too close to the sun? But really the point is when the heroes attempt to overstep their boundaries of human limitations and assume godlike status, and then the actual gods tend to humble them. Now, we'll follow up on how this applies to the U.S. Supreme Court in a moment. But first, I just want to remind you to subscribe to our channel. Help us make Legal AF the best, biggest, and most comprehensive channel devoted to the intersection of politics and law. We're not going to be beholden to any corporate overlords. We want to build this channel with you. So join us on this journey and hit that subscribe button. Now, Humphrey's executor, I gotta love this Mother Jones headline talking about it, which is the Supreme Court makes sure the law does not get in the way of Trump's takeover. And you'll shout out to them and to the reporter for that headline and the work from it. Basically, this is a case where the U.S. Supreme Court continues the expansion of Trump's powers. And in particular, they continue it by using their emergency docket. And that's where the hubris is going to come in. Basis of this case, Trump tried, or now is being allowed to, fire members of the National Labor Relations Board and the Merit Systems Protection Board. That firing action is barred by Supreme Court precedent, the name of which is Humphrey's executor. Dates back some 90 years, even older than the Roe v. Wade precedent that was overturned by the Supreme Court, even older than the so-called Chevron deference case, which meant that you give deference to federal agencies. Older than all that, 90 years, almost a century. It was established in the case of a guy named Humphrey, William E. Humphrey, who had been appointed to the Federal Trade Commission, not once, but twice. However, when the new president at that time, a guy named Franklin Delano Roosevelt, came into office, he was like, I don't really like the idea of having these Republican appointees on this important commission might stand in the way of his New Deal legislation. So he wanted to get rid of him. But the question was, there is a law, as there is today, that says those members can only be removed for cause. They have to do something wrong, malfeasance, neglect, corruption, whatever it is. You can't just decide to just get rid of them because you don't like their political party. So Roosevelt first tried to write a nice letter to William E. Humphreys and say, hey, I think that it'd be better if you resign because I'd rather have my own personnel there. Humphrey asked for a little time to consider it, didn't resign. FDR sent him another letter, a little stronger. We'll put up the text image of it. It says, you will, I know, realize I do not feel that your mind and my mind go along together on either the policies or the administering of the Federal Trade Commission. And frankly, I think it is best for the people of this country that I should have a full confidence. That's the letter from FDR to William E. Humphrey. Humphrey refused to resign. And so FDR lost his patience and he fired him. Sent him a letter that says, effective immediately, you're gone. 5 months later, Humphrey died. Now, just as a side note here, a little bit suspicious timing. Actually, we have the death certificate. He was not assassinated. That's like a little side rabbit hole people have gone down on the internet. But the executor of Humphrey's estate litigated the case all the way to the U.S. Supreme Court, seeking Humphrey's back pay, saying you improperly fired him, his estate deserves all this back pay. Supreme Court took on the case, ruled unanimously in favor of Humphrey, finding that FDR had exceeded his constitutional authority. And they reasoned, quote, if Congress is without authority to prescribe causes for removal of members and limit the executive power of removal, then that power at once becomes practically all-inclusive. We think it plain under the Constitution that illimitable power of removal is not possessed by the president. Fast forward to today. 2 different federal trial courts agreed with that 90-year-old precedent and found it quite plain that Trump lacked the power to remove Gwen Wilcox from the NLRB, National Labor Relations Board, and Kathy Harris from the Merit Systems Protection Board. These lower courts enjoined Trump from doing that, told them to keep those officials in their respective jobs while it's being litigated. The termination is being litigated. But in the meantime, they said, freeze it, our friend, preliminary injunctions, temporary restraining orders, don't do anything until we get a chance to litigate. Trump, DOJ, ran to the Supreme Court, asked them to intervene on an emergency basis, and in a 6-3 decision from which the 3 liberal judges dissented, the current Supreme Court sided with the Trump administration, dissolving those stays. Now, it's particularly ridiculous that the court recognized that the relevant statutes, this is a quote from their opinion, the relevant statutes prohibit the president from removing these officers without cause, and that no qualifying cause, no cause was given. Gee, how does that work? That's why the Mother Jones headline says, who cares about the law, right? Well, they gave short shrift to that law and to the precedent of Humphrey's executor with some lip service, which really is just covering their idea that they like the unitary executive, giving the president more and more power. Because they said, well, these 2 agencies, ultimately, I think we're going to decide that they're much more purely within the realm of the executive body. They're not really independent agencies. And because they're kind of worried about what might happen if Trump got rid of the chair of the Fed, like he's always been talking about doing, what that might do to the economy and stability, they kind of gratuitously said, but by the way, this wouldn't apply to the Fed. That's different. The Fed's more like, they said, like the first U.S. bank, things like that, way in ancient history, because they don't want the Fed to get messed with. Now, keep in mind, the Fed was not an issue in this case, right? They just wanted to point that out in their rather hurried decision here while allowing Trump to do this, to violate Humphrey's executor and violate the law. Now, how did they do this incredibly important triumph for Trump? Did they give it careful consideration? Was there a briefing? Were they looking at the lower court appellate decisions? No. It continued this very alarming trend where they not only kick away precedents they don't care about, but they did it on the so-called shadow docket again, the emergency docket. They're just using it constantly here. And really, as we've discussed before, the backlog is getting so crazy on that docket that it's got to hurt their ability to do the regular cases that they've had merits for. The Hill put it nicely, saying, quote, forget 911. When the Trump administration has an emergency, it just calls 9 justices, that is. The court takes on pretty much all the cases Trump asks them to take on this fast-track basis without the normal processes of full litigation in lower courts, in trial courts, and then full litigation in the courts of appeals. Recently, Chief Justice Roberts was practically bragging about them taking it on. This was in the context of the birthright citizenship case and national injunctions. He says, I think we did the TikTok case in a month. And that's a remark which made the Berkeley law dean remark that, gee, Chief Justice Roberts seemed somewhat more sympathetic to the Trump administration position against nationwide injunctions, meaning Roberts thinks they can do it all. We don't need these lower courts. We don't need those stinking lower courts doing nationwide injunctions, considering things. We can just do it. Bring it to us. We don't need these other courts. Now, that would make the Supreme Court not the court of last resort like it's supposed to be, but the court of only resort. That's the only court you have to go to for the Trump administration. Legal analysis in the case was terrible. They used the balancing test. They properly looked at harm, right? But the Supreme Court concluded, gee, the harm to the government of not being able to fire an attorney is irreparable. It outweighs the harm to the employee. I don't know how they figured that. I'm saying the employee can get back pay the way Humphrey's executor did, right? They're really missing the point. The real harm is to the system. And the point here is that you have independent agencies to give stability to the system so that presidents who aren't kings, aren't rulers, can't just come in and say, okay, we're getting rid of everybody here. We're putting in my cronies, totally upend the particular system and the structure of the institutions. That's why you have independent commissions like this. So what's the Supreme Court doing here? Are they really just terrified of confronting Trump? They're afraid that if they really come down hard on him, that he'll just refuse and he'll bring on the cliched veritable constitutional crisis, which to me, as you know, is defined as when the president says, come and get me, where are your guns, right? That's what I think the constitutional crisis is. They seem to think that they can kind of piecemeal things out, maybe string Trump along to some extent, and that's how maybe they can control him. But here's the hubris part, the arrogance. They don't want the lower courts to do that, to let the process run its course. They want to take it upon themselves to decide all these things. They want to decide when you can have an injunction nationwide, when you can say no to Trump. But they seem pretty avoidant, right? I mean, even in the case of Abrego Garcia, even though the administration conceded mistake, the Supreme Court's too chicken to say, bring him back, right? They have this wishy-washy directive, facilitate the return, which means, of course, he has not been returned at all. So that's what the problem is here. They're at once super conceited, feeling that they're the only ones who can do it. And at the same time, they're kind of afraid to really take Trump on directly. Where's the real loss? Well, by nature, appellate courts want to be restrained, judicious. They don't want to reach out unnecessarily to make broad rulings when they don't have to. The Supreme Court justices are the epitome of that traditionally. They want to select the cases very stingily and make the rulings as narrow as possible. But they can only do that when they have good lower court records being developed and appellate courts which have gone down the different trails of analyses, so they can pick and choose how restrained to be. When they can't do that, then either they're recklessly changing laws, voiding laws without any full briefing or explanation, or they're still trying to be restrained, so it just becomes avoidant behavior. Instead of telling the Trump administration this is wrong, they're afraid to do that. So it emboldens the Trump administration to continue its overreach. And if that continues in this direction, it totally undermines all of the judiciary's effectiveness. And against Trump, who's going to give him an inch, he'll take hundreds of miles. It's going to ultimately undercut their effectiveness, probably to the point of irrelevance. So we'll keep an eye on this disturbing trend. And thanks for watching. Thanks for weighing in. And I look forward to talking to you soon.
I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.